Hello and welcome to the Rogers Brief for June 18th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. Recording this on a Sunday, which is a little unusual, but was tied up Friday and Saturday. Friday all day actually with a sentencing circle. My first sentencing circle experience took place down in Scotia, and that worked out very well. A good experience for everybody, cathartic for the accused, and I think some of the other people that were involved in the sentencing circle as well. And then yesterday, Saturday, I was coaching some ball in the morning and doing some other things during the day. So anyway, getting to this, and it's going to be a busy Rogers Brief this week. I'm covering 9 different stories, and those are some Nova Scotia related issues, judges shortage or alleged shortage, and some comments from the retired Director of the Public Prosecution Service made the news this week. Talk about that. Crown has cross-appealed the William Sandeson verdict from a few months ago. There was a case this week involving some lobster, lobster case with $170,000 worth of lobster allegedly wrongfully put back into the water by the Department of Justice. So we got a verdict on that this week from Justice Rosinski. Case out of the CP Allen School. I've talked about this a few times. A 15-year-old's charged with attempted murder, and he has entered his plea. Glen Assoun, wrongfully convicted after 16 years in jail of murder of Brenda Way, has died at age 67. A few comments on Glen Assoun and his battles and long path to exoneration. Then I'm going to turn to some national stories. The Canadian Civil Liberties Association has made some comments on some new federal legislation on police and border services oversight. And there's a decision this week from the Supreme Court of Canada, a big, long anticipated decision on the Safe Third Country legislation. This legislation covers asylum seekers that are entering Canada across the Canadian-US border and what's supposed to happen with those individuals. And then finally in Canadian news is the retirement of Justice Russel Brown from the Supreme Court of Canada under unusual and troubling circumstances. And the last thing I'm going to cover is a story out of the United States. And like most legal stories out of the United States, it's to do with former President Trump. But what's happened, you may know that he's been indicted on some issues of confidential top secret documents that he withheld, didn't return, wouldn't return. Well, it turns out most of the case is built on lawyer notes, notes that his own lawyer, Trump's own lawyer, took of conversations, instructions, discussions, and those notes unusually had solicitor-client privilege overridden and were used by the prosecution. So I'm going to talk about that and how that would be handled if the situation were to arise in the Canadian justice system. All right, so other news. First of all, I guess happy Father's Day to everybody. I guess that's something I was going to cover, and I'm fortunate to both have my father and be a father, and so good day for fathers all around. So sending my best wishes to the fathers out there. And just to mention that tonight at 9:15 p.m. I'll be on the Nighttime Podcast, a live YouTube broadcast with Jordan Bonaparte and Paul Palango, talking about updates on the Mass Casualty Commission. And it's been a few weeks since I've been on, so lots to talk about there, including the appointment of Justice Oland to head up the implementation oversight committee. It's not quite clear exactly, but we'll talk about some of that tonight. And so you're more than welcome to join that. We're also going to talk about with Jordan. I've talked to him a little bit about doing a release event about my book, The Post-Atheist 21st Century. And so about that, a little bit about what we're planning. We'll unveil a little bit of that tonight too, and then I'll talk about that and promote that as well through my own channel. So you can follow me here, of course. I post these videos to YouTube cross-post to Facebook and Twitter, so you can find me on all of those platforms. So, okay, into the news. This week, Martin Hirschhorn, who's the former director of the Public Prosecution Service, the Crown Prosecutors of Nova Scotia, retired 15 months ago, has not been replaced. He mentioned that in his article as well. Very critical of the Department of Justice provincially. Now, this goes back to some comments a few weeks ago that Pam Williams, the Chief Judge of the Provincial Court of Nova Scotia, made at a sort of State of the Courts address, that provincial court judges are overworked. There's too few of them, and they're handling more and more complex cases. There's burnout situations, and most recently, and cases are not being heard in a timely manner. Most recently, this child molestation charges, which were stayed out of Dartmouth. And it was the case that a judge had heard the case, was ready to deliver a verdict, and then went off on sick leave, was not replaced, was uncertain as to when the judge was going to come back, and then eventually a delay application was brought forward by the accused and was granted by a new judge, Judge Bronwyn Duffy. Noticed over the last few months a few of these delay situations where, these are not good cases. It's always a sign of failure if the court has been unable to process a court trial in a timely manner. Somebody on either the Crown side, the court side, the police side has done something that has caused the delay, an unreasonable delay, and so the charges get stayed. Well, I've noticed that the courts have seemingly assigned these brand new judges, including Judge Duffy. It was Judge Hatt a few weeks ago that I talked about a case which had a delay issue. These new judges are getting burdened, I would say, with these cases where they have to then come in and give the unpopular decision that the cases are being stayed. So anyway, just something. Anyway, that's trial by fire in a sense for the new judges as well. They're going to have to get used to making unpopular decisions in cases and just do the right thing no matter what. But I did notice that that's been a little bit of a pattern developing. So a new judge has been named this week, Angela Casely, a federal Department of Justice prosecutor, 1999 called to the bar. So she's been around for 23 years, 24 years as a lawyer before being named. But I guess the issue is, there's still just not enough judges. We've noticed certainly in the Strait area and Cape Breton, there's not enough crowns either. Port Hawkesbury office, right at the moment, does not have a crown. They usually have two. And Sydney has lost a few crown prosecutors to retirement. One's out on leave, and another one moved over from the Crown Office to legal aid. So some questions about the complement of prosecutors as well. So some shortages all around in the criminal justice system in Nova Scotia. I know on the legal aid side it's perpetually underfunded, and that's an issue throughout. So anyway, we'll see. I know the Minister of Justice has pushed back on some of these comments from Judge Williams, but looks like Martin Hirschhorn, he felt, of course, Judge Williams can't say anything back publicly other than what she said in her remarks to comments directly from the minister, but Martin Hirschhorn felt the responsibility and the ability as a retired director of the Public Prosecution Service to say something. So certainly there needs to be a fire lit under somebody in the department to bolster the ranks and ensure that access to justice and the justice system in general is operating at full capacity, or at least at an appropriate capacity. Okay. We'll follow that story as it develops and as perhaps more judges get named. Still one short of the full capacity of 28 and one on sick leave, long-term sick leave. So, there still needs to be more judges named. Okay, quickly I'll talk about the next story, which is the Crown has cross-appealed the William Sandeson verdict. Now, Sanderson, while in custody, filed a handwritten, that is to say, filed it himself without a lawyer, appeal of his conviction on second-degree murder charge. With Taylor Sampson, the Crown has cross-appealed, I think because, I haven't read the documents, but it looks like it's due to the 7.5 years of parole eligibility time frame that was fixed by Justice Chipman, that the Crown is appealing. But anyway, we'll see. I don't imagine they may have appealed as well on the verdict itself, because they had charged Sanderson with first-degree murder. I didn't think they had a strong case on first-degree pre-planning. But the parole eligibility, they may seek a guidance on that from the Court of Appeal. Although 7.5 years, he was already in custody for almost that long to begin with. All right, next story, story number 3, and this was a case, Rockville Carriers versus the Attorney General of Canada. Decision of Justice Rosinski, and it was involved a Yarmouth lobster buyer, that is Rockville Carriers, who had 4,400 pounds of live lobster seized from them by the Department of Justice by a fisheries officer and released back into the water. Among other things, they complained that the lobster were not released directly into the water from next to their lobster pound, because that was salt water and it could have handled the lobsters. They were released somewhere a little further away. Anyway, that's secondary. Rockville was represented by Richard Norman of Cox Palmer, and Jeffrey Waugh from Patterson represented the Attorney General. Interesting that the Attorney General was not represented by lawyers internal to the Attorney General, but had outside counsel. So the situation was this gentleman, David Pictou of Kiley and Boys was the name of his boat, I think, did not have a commercial license, brought in lobster to Rockville, and then Rockville was not charged themselves with anything criminally or regulatory, but they argued that they were a bona fide purchaser for value without notice, that under the circumstances they had no idea that this gentleman was not a commercial fisherman, thought he was, had known him for some years, hadn't bought from him before, but thought he was a regular fisherman, a commercial fisherman, had a license, had been around. Well, the court said that is not appropriate due diligence. It's a strict liability offense to have illegal lobsters, and so you need to show in those cases that you did everything you should have done or could have reasonably done to determine whether the lobsters were legal and fished properly, and he didn't do any of that. Hadn't asked for his license, and didn't ask where the lobsters originated, what zone they were from, and so the court found that no, despite the fact that Rockville had paid David Pictou for the lobster, so they're losing money as a result of all this, that it wasn't the federal government's fault that they enforced the law and seized the lobster and returned them to the water. So that was rejected. We'll see if Rockville determines whether they wish to do an appeal. I don't see that being a wise course of action in the circumstances. I don't think an appeal would be successful. Okay. Story number 4, the C.P. Allen youth. I just call him the C.P. Allen youth because where he's a youth, we don't know his name. Charged March 20th with attempted murder, among other things. 11 charges, most of them duplicate. There's 2 people injured as a result of a knife being wielded by the youth and used. Attempted murder, aggravated assault, I think assault with a weapon, variety of charges. He's been in custody since March 20th, seemingly with nowhere reasonable to go. Now he has a bail hearing. First of all, he's entered a not guilty plea. I guess that's the key. As I thought from the beginning would be the case, particularly with the most serious charges of attempted murder, that seemed way over the top from the Crown's side to be charging this youth with attempted murder. But anyway, we'll see how it goes. Not guilty pleas to all the charges. The story covering this didn't list his trial dates, so it may, but those, well, they may or may not be set. There's a bail hearing set for June 28th, and so presumably now the youth has a plan as to where he can go, whether that's home or some other residence, and still, have to deal with the charges, of course, but he can do that out of youth detention facility. All right, story number 5, the death of Glen Assoun. Many people may know the name now. Glen Assoun was 67 years old. He was wrongfully convicted, held in jail for 16 years. Terrible story. He was found guilty in 1999, and what emerged afterwards as a result of some great work by Innocence Canada and other organizations, some of the lawyers, Sean McDonald representing him, that the RCMP had destroyed evidence, had not disclosed investigators' other theories. The victim, the unfortunate victim, she had been in the sex trade, but there were 4 other individuals in her sort of circle who were seen to be capable, or were alleged or thought to have been capable of murder. Weren't really investigated. Glen Assoun had an airtight alibi. There was a knife planted on the scene. Didn't have any fingerprints. Didn't have any evidence attached to it. Just there. It was found after the investigator went to a psychic or a medium of some sort, and she said, well, there's probably, if you just went and looked, there's probably a knife there. Well, anyway, then of course they find a knife afterwards, obviously planted if you look back on it. When it was figured out that Glen Assoun was not guilty of this and somebody else was, he was released, but he was released under very strict conditions at first. This was a number of years, probably, I think 2015, 16. Anyway, I don't know. I should have those dates. He was released under very strict conditions in British Columbia. The federal justice minister at the time, Jody Wilson-Raybould, had all this information, waited a year and a half and did nothing about Assoun's case. Then it went, when she was removed as justice minister under other circumstances and Dave Lametti took over, a month and a half later, Assoun was released under no conditions, and eventually had the charges withdrawn by the Crown, and he's free under no conditions. In fact, had then sought compensation for his time in jail, received $200,000 as sort of an initial, all right, we know you're going to get a lot more, but here's just something to get you going, payment, and then an undisclosed compensation deal in 2021. Be very curious to see how much that was. I think other wrongfully convicted innocent people would be very curious as well, and to see what that amount was. Unfortunately, didn't get to enjoy his life for very long after his release. So anyway, that's the story of Glen Assoun. Justice delayed and denied in his case. Next story. Those are some Nova Scotia stories. I'm going to turn to the national scene a little bit. The Canadian Civil Liberties Association, I talk about them every once in a while. They're keeping an eye on federal legislation and looking at it from the civil liberties perspective. This is Bill C-20 they're looking at, which is reviewing the Public Complaints and Review Commission. I may talk about this tonight as well with Jordan and Paul, but it's reviewing the supervision of the Canadian Border Services Agency and the RCMP. And I haven't reviewed the legislation in depth, but the Civil Liberties Association is complaining or indicating that there seems to be a lack of independence from the Canadian Border Services Agency and the RCMP and the minister, that the complaints process is basically still internal to those organizations, and so it's not truly independent, and that there's no mechanism for independent access to information by the Public Complaints and Review Commission. They still have to go through the Canadian Border Services Agency and the RCMP to get that information. And then additionally, the Canadian Civil Liberties Association says that this commission is not allowed to look at systemic issues, only individual claims for individual complaints. So some things to look at as that works its way through through Parliament. Not sure if that's one of the few bills that may get passed before the end of this current session of Parliament, or if that will go over till the fall, probably till the fall, but we'll keep an eye on that. Next one was a decision, story number 7, a decision of the Supreme Court of Canada on the Safe Third Country legislation. This was legislation passed in 2004. This has been in the news quite a bit. Maybe people may not understand it, but basically what it is for asylum seekers that, you've heard of Roxham Road and these other border crossings. Well, what happens is asylum seekers are coming up basically through Latin America, through Central America, into the United States, and not claiming asylum there, but traveling through the United States, making it to the Canadian border and claiming asylum in Canada, because the Canadian asylum system is more generous to those seeking it. However, the Canadian government and many Canadians are not happy about that, and it's overwhelming, social systems in border areas that are not used to seeing these big influx of asylum seekers, and so it's been a public policy issue. Well, it went to the so. A few months ago, the governments of Canada and the United States extended that agreement to not just official border crossings, but any border crossing, with a view to try to eliminate these places like Roxham Road, where people are just going across at unmanaged border crossings. Well, the claim that made it to the Supreme Court of Canada was that the legislation was illegitimate, because what it meant is if somebody came to Canada and claiming asylum and had already been through the United States, well, what you're supposed to do is claim at the first place that you can. So what they're saying is that is the United States. Well, these people were claiming that violated Section 7 of the Charter, which guarantees life, liberty, and security of the person, because the United States is not safe for asylum seekers. Well, the Supreme Court of Canada came down this week and said that is not the case. Indeed, the United States and Canadian systems are different, but they're not identical, but they're both okay. And the United States system is not, is not jeopardizing the security of the person for asylum seekers that are going there. So that'll be good news for certainly some of the border towns and other places that were dealing with this influx of asylum seekers. Now that was Section 7 of the Charter. There was another argument made about Section 15 of the Charter on equality grounds, that there was a unequal treatment of asylum seekers. But the argument, the Supreme Court said, wasn't really developed at a lower level, at a lower court level, and so there wasn't a good evidentiary basis to decide that at the Supreme Court level, and they've sent that back to the federal court for further determination, further arguments, further evidence, and so we'll see. It may come yet back, but I think the Section 7 Charter argument would have been the stronger of the two. It was certainly the more direct argument that people were making publicly before this in the news. They were saying, well, the United States is not a safe place for asylum seekers. Well, that's a distinction based on security of the person, not on equality grounds necessarily. Now, there may be certain groups that are treated differently in the asylum process, but I think that's really just a secondary way to get to the Section 7 argument. So anyway, we'll see if that gets pursued any further, or if there's not a legal but a political solution to that that's more satisfactory. Okay. Supreme Court of Canada made that decision. They made that decision without one of their justices. That is Justice Russel Brown. Supreme Court of Canada normally has 9 judges. They have been operating with 8 since February 1st because of the suspension of Justice Russel Brown, appointed out of the province of Alberta in 2015 by Prime Minister Harper. So you may have heard back in January there was allegations that Justice Russel Brown, who was in Arizona at the time, for Scottsdale, Arizona, for a conference, and they were honoring some other judge, and he was there, and they were at the bar. There was people at the bar afterwards, and anyway, all these allegations. Well, so allegations that Justice Brown had behaved inappropriately and had been drinking and these sorts of things. Well, made, I think, inappropriate advances on somebody. Very slow process. So that was, he's been suspended since February 1st. Okay, that's one issue in itself, because there's no authority in the Judges Act for this Chief Justice of the Supreme Court of Canada to suspend another judge. Yet that is what happened. Chief Justice Wagner has suspended Justice Brown since then. Questionable authority to have done so. Second is the Canadian Judicial Council process is extremely slow. I mean, this was a process. This incident, it was in the news right away. Everybody kind of knew the facts right away. There was video which really discredited the complainant. This was, I think, a former Marine, but was very drunk himself, and some of the claims he was making were discredited by video evidence from the facility. Yet the situation dragged on. Somebody will say the process is the punishment. And in this case, Justice Brown, I mean, he's in his late 50s, would have served on the Supreme Court of Canada for potentially almost 20 more years and contributed to other decisions. And here he is gone. I mean, in his view, he made a statement that, he was still defending himself against this, this spurious claim in his view. But he's felt, because it's taking so long, that left the Supreme Court of Canada, an important institution, at a shortage of judges and without a full complement, and he didn't think that was in the public interest, and so he sacrificed himself essentially in the public interest. At least that's how he's portraying things. And it seems reasonable based on what we know about the Arizona incident. So, real condemnation of the Canadian Judicial Council process. And we've seen this before too, with Justice Lori Douglas, who was the subject of, a campaign with photos of her, and somebody that had a relationship with her was trying to blackmail her, and that just dragged on and on and on too, and helped hurt her reputation, even though she had done nothing wrong in the process. So something that really needs to be cleaned up here. Justice Brown was seen as a conservative justice from Alberta, which is unusual, and some would say a breath of fresh air in the Supreme Court of Canada. Certainly good to have a balance of views and voices in a judicial body like that. There's only 9 of them, and so you don't want everybody necessarily aligned in their views. It's nice to have some dissents and some conflicting opinions on what is appropriate about the law in Canada. Anyway, so that's Justice Brown's situation, and we'll see what he does now. He still has many good years of productive time left. Other Supreme Court justices, when they retire, seem to join law firms and have lucrative careers. It'll be interesting to see what develops with Justice Russel Brown's career after this. I think he's tried to maintain his reputation through this. Unfortunate that the Canadian Judicial Council didn't do things in a more timely way. Okay. Last story, out of the United States. Okay, so this, I sometimes talk about these United States stories and then I think, well, what would have happened in Canada? And a lot of the time they're just, it's just a bigger jungle down there and things aren't always the same. So former President Trump's lawyer, Evan Corcoran, hired, the allegation, President Trump, as others have, other Vice President Pence, now President Biden, others, sometimes when they leave office, they take some documents with them. It turns out some of those are classified and they need to be returned. Well, in this case, President Trump was reluctant at best, I think, to return the documents. And so at one point, the Department of Justice issued a subpoena for these classified documents. And so at that time, Trump hired this Evan Corcoran to go through the documents, figure out what he should do, and give him advice. Well, normally all of that advice would be subject to solicitor-client privilege and never see the light of day. It's something that Trump could use for, to figure out what his moves were going to be. And that's one of the reasons why solicitor-client privilege is in place, attorney-client privilege in the United States. So lawyers take notes when they talk to clients and they're dealing with people. And this lawyer took notes. He recorded notes into his iPhone and then had them transcribed. Well, those notes and those recordings have been seized by the Department of Justice and used against President Trump to get this indictment. Very unusual. And so the allegation was, from the Department of Justice, was that former President Trump had pressured Corcoran to withhold documents and to lie to investigators, to try to thwart the investigators. And that the Department of Justice brought an application before Judge Howell that this was an exception, an appropriate exception, where those notes and all of those things should be disclosed to the prosecution under the crime-fraud exception. The crime-fraud exception is if the client used legal advice to further a crime. Okay, so we have Jack Smith here, who's the prosecutor. He was involved in the International Criminal Court prosecutions. Quite a guy, apparently. He's done lots of Ironman triathlons and quite an athlete and dedicated lawyer. This prosecution at first seemed to be, I guess, if you want to think of it from the perspective of people trying to have former President Trump prosecuted, this was much more promising because it was going directly at at some of the problematic things. Although, I mean, the first prosecution out of New York involved the Stormy Daniels payments and trying to connect those to campaign financing allegations. I don't think those are very strong. The real allegations I think people want to make against President Trump is that he incited the January 6th riots and was trying to steal an election. Well, I haven't gotten to that yet. This one's closer to that territory, withholding classified documents and storing them haphazardly, showing them to people, certainly is a crime. So that's if we get there. But the way they're going about it, I think, is risky from the prosecution's perspective. And I mean, they have this decision from Judge Howell that, it's an 86-page decision ruling that those notes are, can be used, they can be disclosed. And now there's no evidence that Corcoran did anything wrong. He was asked these questions by the former president. What if we do this? What if we just take these documents out or whatever? And I think, suggestion that he was hoping that Corcoran would do that himself and then just hand the rest of the documents back. But Corcoran didn't do any of those things. And so it's uncertain to me as to whether that original ruling disclosing the solicitor-client documents and the notes from Corcoran will be upheld, or if that might go up to an upper level. Anyway, all that to say is there seems to be moves by President Trump's legal team that they can make to really delay this, certainly to delay it through the election. Although, who knows? I mean, he seems to be getting boosts in the polls every time one of these stories comes along. Maybe he'll want the trial to happen before the election, and maybe he'll want it to be broadcast. I noticed his arraignment was not broadcast. There was no photos from inside the courtroom, no videos or anything from in there. Now in Canada, there is also an exception. So there's not too many exceptions to solicitor-client privilege. I mean, one is if somebody comes in and tells you they're about to commit a certain kind of crime, if they're about to kill somebody, if they're about to, burn a house down, or, something where there's a danger to the public and you're very certain that it's going to happen, well, the lawyer's obligation is to breach solicitor-client privilege and tell somebody. All right, well, that's not here. There's a crime fraud exception, and there's 3 criteria. First, it must pertain to proposed future conduct. All right, so you can't be talking about something you already did. Secondly, the client must be seeking to advance conduct which the client knows or should know is unlawful. And then thirdly, the conduct must be clearly wrong. Okay. The reason, and those are strictly applied, in Canadian law. The reason is, I mean, most of the time you're giving somebody legal advice, it's, you know, they're on this side or that side of the law, and they're trying to figure out where is the line, what is legal and what's illegal. Well, you can't talk about that without saying, well, if you did that, it would be illegal. Uh, you have to tell somebody how things operate. So my question in this case is, well, if President Trump just asked his lawyer, well, what if we did this or what if we did that? Well, that might be a reasonable question, and the lawyer might say, well, you can't do that. You'll get in trouble. Okay, well, moving on then, and you move on, and you figure out the next question, and then you come out with a course of action. So, if you can't even ask the question, I mean, it has to be clearly wrong, and I'm not sure that's the same standard in the United States. I'm not sure that was the standard that was applied here, just looking at it. So, there's a real risk, I think, in this case that first part will be overturned at an upper level of court, and the evidence derived from the search of Mar-a-Lago might just be all thrown out. So anyway, we'll see what happens. There's real potential for abuse in either side of this, right? I mean, the reason the exception is there's a legitimate reason for it, because you could just get your lawyer who knows the law to help you break the law. Well, that's a danger that we don't want, and you have to discourage that. But there's a risk that just by, as soon as you ask a question, well, and the answer is, well, actually, client, you can't do that. Well, is every time that question is asked an instance of breaching solicitor-client privilege or justification, for breaching solicitor-client privilege? I don't think so. So I'll be watching that case very closely, as everybody in the world will be watching that case fairly closely. So we'll report on that as things develop and as we know more about some of the details as things are leaked out or brought out in the court process. So until then, I want to say, all right, happy Father's Day again to everybody, and that's it for this week. We'll be catching up with people on the podcast tonight with Jordan and Paul, and otherwise we'll see you next week. So thanks again for watching, thanks for listening, and we'll see you next time.